Hello, hello, hello. This is Alyssa's fault. I don't know what's going on. As usual. Should be starting any second now.
That the last one going? Yes. Case number 2500076 GC LVNV Funding LLC versus Erica ERYKAH Murphy.
Good afternoon, Your Honor. For case P 78292, LVNV funding and so forth.
All right, good afternoon, Ms. Gates. What's your name?
Erica Murphy.
All right, and Ms. Murphy, we're here today for, looks like a motion for summary disposition. And that would be filed by the plaintiff. So I'm assuming you got a copy of it and read it.
Yes.
You didn't file any written response to it.
I just received it in the mail a few days ago, so I brought my response here. If that's okay.
Okay. Go ahead, Mr. Cates.
Thank you, Your Honor. Is a case of a line of credit from WebBank.
Web Bank.
Yes, WebBank.
Mm-hmm.
That was purchased by LVNV funding. The plaintiff's position is that there has been no valid affirmative defense and that the submitted documents show that there is no issue of fact for trial. So pursuant to MCR 2.116 C9 and C10, we are bringing our motion for summary disposition the same. There are damages on this case of $4,184.18, court costs and service fees of $133.04, statutory attorney fee of $20 for a total of $4,337.22.
I'm just looking at the motion. I'm looking at the promissory note from Web Bank, which is all attached. Okay, so what is your response? What they're arguing basically here is that you read the motion, they come under a specific court rule or 2 or 3, no defense, no genuine issue of fact for trial, and basically that if it comes before me and it appears that they're entitled to judgment, they should get a judgment. And they're saying that there was a loan agreement, they did their part in performing under it, you defaulted under it. It was with Web Bank. They claim that that I guess they're the successor in interest to Web Bank because they bought the debt, and that basically you filed an answer and it didn't really state any what they claim viable defense. They also say that they attached a payment history showing that there were payments on this account. They attached their bill of sale and the affidavit of sale showing that they have the right to collect the debt. So they don't believe there's any issue that would require a trial, because trials need factual issues, and they're saying there is no factual issue. So they're asking the court to enter judgment. So what's your response?
Well, the first response that I have for Exhibit 5 that was sent to my house a couple of days ago.
Exhibit 5. What is that?
There was a
What's Exhibit 5?
basically when I had sent my original response, I basically had said that there wasn't an affidavit that was provided to basically confirm that what they were saying was true. I received the affidavit in the mail a few days ago, and the person who signed it is not from the original creditor. They're from Resurgent.
Okay, what affidavit are you talking about? Because I don't see affidavit. And are you talking about somebody that signed an affidavit claiming that they bought the debt? I mean, what affidavit?
No, basically they were curious.
And so, I'm looking at something you filed and you say you deny entering into a contract.
Yeah, I have a police report, actually 2 police reports that were made in 2022 about my information basically being compromised. The Atlanta Police Department did not do anything about these police reports that I had done in it.
Oh, with respect to this particular debt, whatever web bank is?
Yes, I'm actually going through another court case with another creditor about the, same thing. I don't know if you want it. I have a copy.
And because, so you're basically saying it's not your debt. You never had an account with web bank.
Continue or should I?
Okay, well, go ahead.
So in addition to the affidavit, I believe is hearsay and admissible, the electronic contract is incomplete and unverified, is missing the verification page, IP address, audit trail. So it was just like the last page of the contract, no confirmation, page was attached. And then, I believe that the chain of title was broken. The plaintiff's bill of sale is generic and redacted. It does not reference my name or account, and no authentic data tape or signed assignment documents have been provided. That alone breaks the chain of title. And additionally, I would like to address that this debt allegedly passed through a trust, but the plaintiff has not provided any trust agreement or any documentation showing that the trustee had the authority to sign the debt. And without that, they cannot prove standing.
I don't even know what you're talking about. This account was in a trust.
Yes, so on the bill of sale document that they provided, it had no dates, signatures, and it also listed the 2 or 3 trusts that the account passed through, and they did not provide any information as far as the trust.
See, I don't even
And it also doesn't have my name anywhere on it.
Oh, you mean to show that your debt was a part of what they acquired? Is that what you mean?
Yes, it looks as if it's like a generic page.
I'm just trying to catch up with you.
Oh, okay,
You're telling me things and I don't have those things in front of me, so I'm trying to figure out what we're talking about. So there's a letter in here from March of 2023, says Avant, addressed to you, indicating that your loan has been sold to Resurgent Acquisitions. And no longer serviced by Avant. Okay. And then there's a bill of sale that shows the value received. There's a purchase and sale agreement. It's 27th of June, 2019, Avant on behalf of entities listed in Schedule 1 attached here to as seller assigns effective February 24th, 2023.
That's what
All
Alyssa
the
tells me.
seller's rights, interest, and those certain charge-off loans and related participation interests and all related receivables, judgments, and evidence of debt, and Schedule 1, attached here to and made part for the purpose of Resurgent Acquisitions purchase. And it was signed by some chief operating officer. Then Schedule 1 to the bill of sale dated February 24th. The accounts detailed are sold on behalf of the following sellers: Avant 2, Avant Loans, Funding, Trust 2021, Rev 1, 2022, Rev 1, Avant Colorado, Avant of Idaho, Kansas, Louisiana, Nevada, New Jersey, Oregon, Avant Warehouse Trust 1, NBSF 2018 2 Series 2019-1, Pagaya Debt Selection Grantor Trust 2021 2, 2021 3, 2021 4, 2022 1, 2022 2, and 2022 3, and Pagaya Funding Trust 2. Data take name February 2023, Resurgent final sale, something 202302223.xlsx provided to buyer February 23rd, 2022 is included in here by reference. So then they talk about their transferring and assigning without recourse. All of those rights, title, interest on all of those assets that are identified, pretty much the ones I just went through. And this includes electronically stored business records, and it was signed by Resurgent Jackson Walker, authorized representative. Then there's Exhibit A, receivable transfer 22423, Resurgent final sale 202302223, transfer group 4246, portfolio 1381. And then this final sale looks like they're given line numbers.
Is it sideways? Why is she doing that with her head?
And so, okay. So they do reference things that are in trust, but no, I don't see them mention specifically of your name or account unless you have a separate account number that I'm missing. So that's one argument. And your other argument was that this is fraud.
So I pretty for police reports that are made in 2022. Also the document that you were saying that they sent, a letter to my house, from Resurgent saying that basically like.
Well, it's from Avant
Okay,
saying that
yes.
Resurgent bought it.
That's what I mean, that address is inaccurate, so I didn't receive this, sheet until, the evidence was sent to me, to my house and. But that's not my accurate address.
So you've never lived in Georgia.
I have, but at the time when that was, sent, I did not live there.
But did you live at that address ever?
Yes,
Okay, so it's just you just moved. Okay.
Right, yes, I did not receive that document, so I didn't have a chance to even respond to them or anything like that. Also,
Oh, fantastic. Then everything's
Um,
free. You're okay then.
the,
Judgment for
well, I
you.
already said that the plaintiff sent, documents to an old address that I did not receive until after, and then also when the original claim was served, it was not served to me, it was served to, my mother, so I believe that it should have been something in the mail that should have been addressed to me. I believe that it was in Michigan law. Correct me if I'm wrong.
Yeah, there's something called alternate service, so I don't really know, because I didn't look at service.
Okay.
Service,
Well,
I don't know if service is even an issue for this, but
Well, I just wanted to bring it, to the person's.
yeah, you can have documents. They don't have to give them directly to you. If they can show that they made attempts to serve you personally and they didn't, they can do it by posting something at your known address of record.
Right.
Or they can serve it by regular mail too, and certified mail return receipt. And sometimes it can be to a member of the household too. It could be 3 or 4 of those together, just to be reasonably calculated to find you and give you notice of it.
I would say, the only document that I received was the one that was served to, my mom. So there wasn't anything after that was given to me. And then also, the original contract or no evidence was with that served at all. It was just a sheet of paper, stated claims. I didn't, and then also during mediation, I still haven't received any evidence, no original contract, which they already admitted that they did not have in possession at the time of filing. So during mediation, they tried to pressure me into, basically settling without me looking at any type of evidence or anything like that, so. Yeah, and I don't
Now,
know,
they say they have attached to their complaint a contract, a loan agreement.
that was after the fact, like, after, I received all the evidence after the mediation.
But this was supposed to be attached to the thing that's the documents that started the lawsuit.
It was attached to the
And they
complaint.
admitted
It's
that they did
required by
not have
law.
that
The
in
attorney
their
didn't miss it. I guarantee it.
So which brings me to my concerns of whether the debt is actually validated and.
Oh, I want her tased. I want
and
her
they have
tased.
been.
Well, you're saying it's not, because you're
Multiple
saying it's not
times.
yours. So, what do you want to say? I mean, she says basically it's not hers. She didn't get anything short of whatever her mother received at some point. And then she says there's not enough evidence here to show that you have a right to collect it.
Well, I'll go down the list as they see them. The affidavit, that was submitted by the plaintiff, is a sworn statement.
Now, what does it say? Who's the affidavit of?
I believe it was the affidavit of one of the controllers from LVNB that she handed you. I only saw it before the court office was handed.
I got a police
It's an
report.
affidavit- It's an affidavit from the custodian of records at LVNB. Yeah, who would be party in interest, so that would be a valid statement.
Mhm.
The argument that this passed through a trust, there is no evidence that it passed through a trust, and quite the opposite, when you actually look at the bill of sale and chain of title, the assignment goes avant to Resurgent to LVNB.
But
Yeah,
the
but-
documents look like
The
it's the
documents
grantor
said that
trusts.
there are grantor trusts, but those accounts were other accounts that were in the batch that were.
Well, how do we know where hers is?
Well, because exhibit A has this is it was exhibit 4 on the plaintiff's motion for summary disposition. It is the, redacted batch file that contains the defendant's name and information.
Well, where is that? I didn't see her name anywhere.
If you go into exhibit 4. you'll
Okay, I'm
see
on
the
2.
receivables file marked 2023-0223.
Wait a minute, hold on, I'm on 4-3. 3 is the letter. Oh, boy. Just can't have easy afternoon. 4, Schedule 1 to bill of sale. So where am I going to look here?
The actual exhibit at the end of the bill of it should have the bill of sale and the chain of title documents, and then the exhibit A that's listed in the,
Exhibit 4. Exhibit A. I don't know what that means. It says,
exhibit A is exhibit to the chain of title. That's how they refer to this in the chain.
but how do I know what transfer group 4246? How do we know what's in that?
Because it is referenced right on the first page that they give it the,
Where's her name? That shows that her account is part of
first
it.
page of the badge file.
Right.
Okay.
My response to that.
Everything else is redacted because it's personal information for other people and not to be part of.
Where's her name on the batch file? It's exhibit what?
Exhibit 4, the first page of the badge file clearly says Erica Murphy. And unfortunately, the way these print out, you get little snippets of information on each page, but it's actually a,
Okay, I got a bill of sale. That's my first page of exhibit 4 signed by Avant. I don't see her name on that. Then I go to schedule 1.
but at the bottom of the bill of sale, you see sale file 2023-0223.
I guess my response to that is that it's not specific to me. It's just a batch of files. So
Yeah, I mean, a trial, you'd have to show me that. So she's questioning what is in that, what she has right to do. I don't
Well,
know.
I understand that, Your Honor.
Yeah.
I'm
You're saying here, and I'm looking, I should be able to look at this and say, okay, her name and her account number, and where's that? That's all I'm asking.
That's what I'm trying to explain.
You said, now I
The
see,
whole
I
fi-
see.
The whole batch of files is that first 2023 number.
Wait, where's the 2023 number?
The 2023 number at the bottom of the bill of sale. that
Bill of sale and assignment, exhibit A.
all of the sellers of these accounts.
the transfer of assignment is.
Okay, excuse me. Okay, there's too many people talking at the same time, and I'm the only person that matters here because I'm the only person that needs to understand what both of you are saying, and I can't understand it if you're both talking. So what I'm trying to do for you, Mr. Cates, is you're telling me that it's on exhibit. I'm on. Do you have a page number at the bottom? I'm looking at page 19. It says exhibit 4, and the top of that says bill of sale.
No, it's on page 20.
Okay, now I'm going to 20. So I see all of these loans, funding and trusts.
And at the very bottom.
Okay.
February 2023 resurgent final sale file.
Yeah, I see that. How do I know what that number is?
That number corresponds to this batch of files that are listed in my hand.
To the ones up above? Let's start with Avant 2 LLC and go all the way down to Pagaya Trust 2.
This spreadsheet, this printout of the spreadsheet correlates to all of the sellers.
But how do we know that other than you telling us and you can't testify?
Because I don't understand the confusion here because this is the file. The file that contains all of the information that was bought by Resurgent is right here.
Okay, and what is that? And that's
This is the list of all the files that they bought with the account number.
2023022.xlsx.
Yes, that is this
And you
file.
have it in your hand.
This is in my hand.
Where is it attached to here?
It should be after 19, so it should be starting on, well, this would be the next page, so there's gonna be the page with transfer and assignment that
Mhm.
starts with Resurgent.
I see that.
This should be the next page that it starts.
After that,
Yep,
which would be Exhibit A receivables. And then it says transfer group 424 6, portfolio 1381. It has a batch number and it shows up there 2/24/23, February 2023, resurgent final sale, and it gives 202302223.
which is the number that was referenced in the bill of sale.
Okay, but where is her name on reference in any of
It's
that?
the next-
Which page?
The very next page after the receivables file, it has her name.
Where is it?
It should be.
You want to come up here and show me? You mean you could come up here
I
too?
would be happy.
You want to come see? You could come.
I have a copy.
Because I'm trying to see what he's talking about.
Yeah, just scroll up a little bit. See that? No, you're scrolling too fast.
Yeah, go right here. So this is what.
Yeah, that's the page I was. Yeah, Exhibit A. That's where the overall file is referenced, and right there, you see her name in the middle of it, right below that redaction.
Oh,
bar.
okay, right, okay. You act like this is so clear. I should be able to see it. This ain't clear. I do see something about 2861 and everything else is redacted for the reasons that you said.
Yes.
But 2861 4500 Erica Murphy.
Am I able to respond?
Okay, and 426. And then if you go back here, it's crooked. I can't. 20223. Okay, February 23. Mhm. Loan amount 4,500. Loan ID 2861. Okay, what is it you want to say?
The transfer of assignment and the schedule bill of sale, it does not reference specifically me, my name, or the specific account number associated with the alleged debt. To me, this seems as a generic pages, and like I said, it does not mention any dates that any, of these, I guess, collectors of the account, when they received and sold, this alleged debt. And to me, I just feel like it's just inadmissible. It's nothing saying specifically to me. It's just a batch of files with my.
Well, that's what assignments are, batches of files that are
Yes,
transferred from one to the other.
yes, but on any of these, doesn't list any account numbers, nothing tied to me specifically. I mean,
Well, your name is there.
not on this.
But if you look at what you're showing me, which is the assignment, bill of sale, so you got to kind of read it all as a big whole.
Yes, I have.
And they talk about described in Schedule 1, attached here too. They talk about that in the bill of sale and assignment. And it concludes all the charge-offs, participation interest, receivables, judgments, evidence, and debt described in Schedule 1, which is made a part of here too. And that was all given to Resurgent Acquisitions. Okay, so then that, when you go down to Schedule 1, which is attached, then the document that he's talking about is down in the bottom listed as data tape February 2023 Resurgent Final Sale 2023-0223.xlsx was provided to the buyer February 2023. It's included by reference.
Yes.
Then he says that's what, when you go down further, the attachment with all the redacteds includes your name as one of those files.
Yes, but that is not listed on any expense.
But it's included by reference. Legally, you can do that.
To me, if it's a batch of people's names and account numbers and everything like that, I guess to me, it's hard to understand whether this is actually correct or towards somebody else. If it doesn't have my name or account number, it just seems generic to me. And there's nothing to prove that
Oh, you're
this was
stupid.
actually sold
So it
with
doesn't apply
my
to you.
name, the
Okay.
loan, the alleged.
But it
debt.
says it was, and it incorporates it by the reference to it with the batch file that it says incorporated by reference, and then they list all there's a million names here that were sold at that time, and then they show yours as being one, and the rest of them, for purposes of anonymity, because we don't need to talk about everybody else's personal identifying information, they're redacted.
Yes, I understand. There's also no, documentation for this alleged debt going through a trust or verification of the trust, the documents that come with that.
Well, the trusts are part of, apparently, I guess, what our where some of these files were included in.
Yes, but you need to have a separate, basically bill of sale saying that it went through a trust.
No, because this bill of sale does say that these were all part of these trusts, and this document was a part of it. It says that.
It was a trust in these files, or they received, or it went through a trust, there needs to be documentation for that trust, that it was assigned to someone else, and no one provided that.
I thought that's what this said.
No, this is for,
She's trying to argue that this was the sale by a trust. which-
It's not a sale by a trust. No, it's not.
I'm saying that
The trust.
Yes.
The trust is a. But I mean, but it's a.
right, but you don't have any documentation for that. That's what I'm saying.
Documentation, it's moved. The trust isn't the.
Well, I feel like it should be. I feel like that's important.
Well, your feelings don't matter. Law only requires us to have the. people
Well-
that directly sold their bonds.
Regardless of the fact, it has no dates. My name is not mentioned. I do acknowledge that there was a redacted file with a lot of people's information a part of that. I do understand that. Like I said, I have provided a police report saying that my information was used or compromised at some point in time during 2022. This debt does not belong to me. And as far as payments being made on my behalf, I will say that payments were made just because of the fact that I was by myself living in Atlanta, no money because my accounts were closed. I will reference what I provided in my exhibits. They were closed shortly after this alleged loan.
Wait a minute, I'm lost. You made payments on this?
Yes,
because-
explain why.
On a debt that you said wasn't yours?
Yes, because it was being reported on my credit
something we call
report, and
affirming the
because of
debt.
that, my credit score was going down. Me being freshly out of college, didn't really know what to do with that, and so, yes, I did make payments on behalf of that. But yeah, realizing now, this debt does not belong to me. And at the time, I didn't really know how to go about that, especially when police reports were made and nothing was done about them, so.
Especially, not especially.
What was you going to say?
Your Honor, it's an impossible situation. The fact of the matter is that the plaintiff does have the account transaction. Payments were made. There were no objections filed to the account when it was open.
She said she didn't know.
College
and
was
she
an
didn't
abject
live
failure.
She didn't live at the
Top to
address
bottom.
even.
And anybody could say, well, I bought this car and I paid for it, but then I realized it was 11, so. Yeah, or that's a bad example, but they'd be able to. Simply argue away that I didn't know that this was the city bank accounts we were talking about in any given case.
Well,
That's not, there's no way to prove or disprove the defendant's allegation that was just made on the record.
Well, the police report-
The fact of the matter is that there was an account, there was.
How do we know it wasn't fraud? She can make an affidavit, which her statement here today, I can swear in, and she's stating that it was a fraudulent account. Wouldn't that be something that a trier fact would need to see or hear to make a determination? Maybe, and I'm not saying you're not right about that. It looks like her account was included in the sale. I don't have a problem with that. But she's saying that it's not her account. So wouldn't,
There were payments made by the defendant,
yes, because it was being reported on my credit report.
but there were.
And it was
payments
affecting
made-
my
there were-
credit.
what does payment made mean that that's her debt?
that constitutes use and acknowledgement of the account. Yes, by the user.
Personally, don't think that trying to correct my mistake is a bad thing. I don't really get why you're trying to say, why would you do this? But now you're saying this, I mean, I have a police report. I've provided you guys with a letter.
I mean, really, realistic, let me tell you what happened. If I even do grant this, deny this motion and rule in your favor today, all it does is end up going to trial. It doesn't go away. It means that we go to trial. They're gonna present the same thing. Hopefully, that's what they do that they're presenting today. And then you gotta present something that shows that this is not your charges, even though you paid for them, some of them, and that this was fraud.
Yes.
And I don't know if you could reach that burden, and then you might still be liable for it. I just don't know. His position, he's trying to argue the law, which he's claiming says basically that if you use an account or pay for an account, I think he's arguing pay for in this instance, then that means you're affirming the debt. Now, do you have a case law on that? I know that if we say you use it, that's one. She's saying she didn't use it. She's just saying she paid.
Thing in the brief, I have a case. Pressing that.
I don't think so, because I just looked, unless I don't have the brief. Because I did look at your motion, and I don't see a brief attached to it. Oh, here is a brief. Wait a minute. It's right here. It's a separate document. You see what you said. Brief.
Unfortunately, they didn't give any case law.
Right. No, it's just a one-page brief. And so, when they say there's no genuine issue material fact, I can't say that because fraud is a defense, for sure. And it could be an issue of fact as to whether or not this is her debt or not, even if she pays. And I don't really know what the case law would say about if you paid a debt, but it's not yours, does that really make you liable for it because you paid it once or twice? I don't know.
But it wasn't once or twice.
I don't know how many times. I don't have any receipts showing how many times she paid it.
Well, you do, as a matter of fact.
I do.
It's Exhibit 3.
Oh, okay. Well, you can tell me.
And there is, at minimum,
I'll tell you what
there were several.
I'll tell you what I'll do for you, Mr. Cates, rather than rule on it now, because I got the issue of fraud, and I'm very sensitive to that. But if you could find me something that says fraud or no fraud, if she affirms the debt just because she paid for it, even though she denies usage of the account ever, if paying for the account is enough, then maybe you win. What is it?
I'd like to reiterate, the only reason why payments were made is.
I heard you the first couple of times you said it. You made police reports. They didn't do anything, which they don't usually unless they have a lead. You just make a report. That's usually it, unless they have some lead on it. You made the reports. It was on your credit report. You were young. You were just out of school, and you didn't know how to handle it, so you just made some payments. That's what you told us, right?
Yes.
I got it. I listen. So you can look too. You can, so since you both want to research that issue, I'll give you an adjournment on it, and you can sort of come back and see what does the law say when the defendant denies making the account at all with the underlying creditor, but made payments. Does that enough to create no issue of fact when they're alleging fraud? Okay, so let me make a note on that. And where's Jessica? I need a date.
A date?
Mm-hmm. And so, and what I would also suggest you all do in the interim too, she gave you a copy of her police reports. Maybe you take it back to the client and see what they do. You know, maybe they told her to fill out a fraud affidavit. I don't know, but you need to probably look into that too.
Are they coming back for a motion for something?
Yeah, we're just gonna finish this.
I don't know. This seems reasonable. There is potential for fraud here based on what she's saying. I don't believe a word she says, the defendant, but I don't know. So now you've injected an issue that needs to be
No.
adjudicated.
Well, it can't be this month because that's next week.
Well, yeah. Okay, court's available September 23rd at,
September 23rd.
yeah. The
That's
court-
all you get?
Court is booked, unless I do have a suggestion, but I actually.
Not some, but all their cash.
That's what it is. What about August 12th? What time?
10 a.m.
I think the ultimate result is she loses. But she either wants the case law or to have a hearing and let her try to show the fraud, which I don't think she'll be able
August 12th
to do.
at 10 a.m.
That works for Plea.
What about you, man? So could somebody submit those to the court? If you find case law, either one of you, just submit that as a supplement to your responses. You can file a written response since you didn't do it because you say you just got it. Now you can file a written response. And if you find any case law that basically says, hey, it's the opposite of what he says, then cite it. Show me what it is. Because he's claiming he's going to try to find that there's a case out there that says even though you deny it, that creates a question of fact on the fraud, that by you paying it, that makes you affirm it and you're therefore liable. August 12th. And I'm going to put down that you're going to talk to your client about the affidavit of fraud, and you've got your current address here?
Yes.
You have that, Mr. Case?
The defendant's current address?
Yeah.
The
No, we're not dealing with that. I'm not doxing her. I'm moving to the Brecken portion of this here.
Can you hear me? Oh, can you hear me? Is that creating interference?
I can't hear you loud enough.
This is the other part, so.
He needs to have this part turned on
Oh, okay.
and the microphone by you so that he can.
You're on. Okay, there we go.
Should be better.
All right. Can you hear me now?
Very good.
All right. Very good. So, sir, would you state your name, please, for the record? State your name for the record.
David Wayne Tenwalden.
All right. Very good. Ms. Strasser, as an officer of the court, could you state your understanding?
Yes, he is going to be pleading guilty to file 252186 SM for dismissal of the other file 252259 SM and a guilty plea to domestic violence.
All right. Sir, you heard what your attorney stated, that you'd be pleading guilty to the domestic violence charge in file 252186 SM. And the other file, also a domestic violence charge, will be dismissed. Is that your understanding of the agreement? All right. Now you understand, sir, that you have a right to proceed to trial. And if you did proceed to trial, the prosecutor would have to prove that you're guilty beyond a reasonable doubt of each of the charges made in both cases. You
That would
understand that?
not be a problem. I was guilty.
Be that as it may, I need to go through this to make sure you have an understanding, okay?
Yeah.
But you understand, if you did go to trial, the prosecution has the obligation to prove that you're guilty beyond a reasonable doubt.
Right.
You understand that if you make a plea here today, you're going to tell us you're guilty to the one charge, and the people will dismiss the other charge. You understand that?
Yeah.
You understand there will not be a trial of any kind.
Right.
All right. And that's your intention.
Yes, sir.
Has anyone tried to frighten you or force you into doing this?
No.
Has anyone made any promises to you that I am not aware of or that have not been placed on the record?
No.
Are you currently on probation or currently on parole for any other criminal conviction?
Just domestic violence.
Are you on probation or parole right now for an existing?
Yes, sir.
You are. All right. And where are you on probation?
Allegan County with Katie Kudowski.
Okay. You understand that this plea may well have ramifications with that.
Right.
Okay. And you wish to proceed with the plea?
Yes.
The allegations, sir, are that this is an incident that occurred on June 22nd, 2025. Does that sound correct?
Yes.
The allegations are that this incident occurred in Lee Township of Allegan County in the state of Michigan. Does that sound right?
Yes.
The allegations are that you made an assault or assault and battery on Sean Wayne Burkhead. Is that true?
Yes.
Who is Sean Wayne Burkhead?
He is my grandson.
And what did you do that makes you guilty of domestic violence?
At that time,
At this point, yes. What did you do to him that makes you guilty of domestic violence?
it's very verbal and made threats against him.
I didn't hear the last part.
Made threats against him.
Did you place him in fear of physical harm?
No.
Would a reasonable person have felt that they were in danger of imminent physical harm?
No, not at that time.
Your Honor, may I
Ms. Strauss?
inquire? May I
I
inquire?
was just going to ask if you want to inquire.
Mr. Tenwaldy, at that time, did you threaten your grandson with a fork?
Pardon? I can't hear her.
Did you threaten him with a what?
A fork?
Did you threaten your grandson with a fork at the time?
Yes.
Okay.
Would that
And
have,
wouldn't that be something that would cause someone to fear physical harm?
Yes, it would.
And that's what you did.
Yeah.
All right. Are you satisfied with the plea?
yes, I am.
Sir, you provided me with the basis to accept the plea. I will do so.
I do accept the plea.
I don't see that there's an open domestic violence case that you're on
He's been
probation.
placed on diversion.
Oh, it's on a diversion?
Yes.
Has he completed the diversion?
No, he has not, and we did discuss the implications of this.
Do we have victim notice on this?
Do
I believe we
what?
have to set for sentencing. We did want to go on
Very
record
good.
regarding the no contact order, though.
All right. Go ahead.
I have spoken with both grandsons, both alleged victims in this cases, as have the prosecutor's office, and neither of us are opposing that the no contact order be amended to non-assaultive contact.
All right, I'm going to amend the no contact order to non-assaultive contact. Set this matter for sentencing at a later date for victim notice. And you are all set, sir. You can leave the court. Non-assaultive contact means just that, non-assaultive contact. You understand that?
Right.
You have to conduct yourself with civility. All right? All right, you're all set. You can leave the court.
Thank you, sir.
There you have it. Looks like Zach baked up a good one for me, but I think I'm going to do that in the morning. Thank y'all for coming out. Sorry, I had a nap in the middle of the day. I did. I had a nap, and it was excellent. Behave yourselves. Take Uber. I'm not bailing you out.